Family Law. This is your podcast for the child support section of the course. We're going to talk about child support specifically in Illinois, but we'll also talk about some of the origins of child support enforcement, establish paternity a little bit. We'll get into that in the later weeks. We'll talk about typical guidelines for support obligations and how income from child support is supposed to be treated. I wanted to clear up because I had this question recently. What is an IVD? That's capital IV /D or hyphen, I guess, D agency. In 1974, the Child Support Enforcement and Establishment of Paternity Act required each state develop a comprehensive child support program and to designate a single state agency known as the IVD agency to administer the program. And not only did they try to establish paternity for the purpose of making sure that people who should be paying child support were paying child support, so paternity, that means the male who wasn't present or wasn't helping support children, but it also set up systems, and it came a long time after 1974 for Illinois, where we could get some reasonable expectation of actually collecting that child support and paying that child support out to the person who's supposed to receive it for the benefit of the kids in some reasonable format, for some reasonable way. And prior to that, there were all sorts of things that went on. So some basic services that IVD agencies might provide: assistance in locating absent parents or parents who are trying not to pay child support. And some of you may have experienced that or know people close to you experience that, and that does exist. Establishment of child support awards, periodic review of the awards, enforcement and support of the awards, and then where necessary, establishment of paternity. And it essentially created some expectations that you knew if you're supposed to get child support, that child support would be paid by the employer to the agency and the agency to the recipient. Before that, there were all sorts of things that went on. People might pay in cash, they might pay by check directly, there might be all kinds of disputes about whether somebody paid or not. And typically the only court order that would relate to child support, I think at one time people would pay to the county, and the county clerk, the circuit clerk, would make those payments. In fact, I know that's how it was for like my parents back in the 70s. We got divorced shortly before this act came into effect, and long before anything was ever done to comply with the act in Illinois. So it provided some consistency. Definitely has been a good thing. So let's focus, after answering that question, on child support. So there's various types of formulas, and so there's percentage of income shares, and then what some refer to as the Melson formula. The percentage of income model sets support as a percentage of only the non-custodial parent's income. The custodial parent's income is not considered. This has two variations: a flat percentage model and the varying percentage model. And various states use the various models. Illinois is sort of a hybrid, and we'll talk about that in a minute. But we do look at percentage of income. Now, traditionally, that was based on a non-custodial parent, because now you find more and more people who share custody of kids on a co-equal basis. When I was divorced, to just give you a personal example, I was divorced before the current law, so before the time and responsibility statute that you just reviewed and those elements. But essentially, we shared responsibilities and we shared time pretty much to the hour. We had 2 full days per week and alternating weekends, and so it equaled out that way. There was certain days that neither of us had the kids, but we lived 5 blocks away. They went to the same school. We shared all the responsibilities, and that's the modern way, as opposed to when I was a kid, where I really actually saw my dad, even if he was supposed to have us, but his original visitation schedule was supposed to be one evening for 3 or 4 hours during the week, and then every other weekend. So my mother had the 4 of us for the vast majority of the time, and actually we just didn't really see him. So she had us all the time. That's what that was based on. And so now, after you're familiar with how our custody and visitation under our current statute, how those old terms work, you can see how that applies. Income shares is another model, and it's based on the concept that the child should receive the same proportion of parental income that he or she would have received if the parents had lived together. In an intact household, the income of both parents is generally pooled and spent for the benefit of all household members, including any children. And Illinois is sort of in that camp. And again, I'll talk about Illinois specifically, and hopefully you did as I asked and you already took a look at the statute, but this will help you go back to the statute and maybe better understand it. The Melson formula was more complicated. It's a version of the income shares model, and it incorporates several public policy judgments designed to ensure that each parent's basic needs are met in addition to the children. So I kind of had a little more focus on the parents as well. It developed through a Delaware family law judge, and it's specifically explained in Dalton versus Clanton, 559 Atlantic 2nd, 1197, a Delaware case from 1989. There were only a few states that ever bit to use or adopt that. Commonly, factors that were used to determine child support, no matter where you're at, the income of the custodial parents, so the person who had the children more. When we say custodial, and we still use those terms even though we don't use those terms, right? Those terms aren't supposed to be part of our language in the statute, but everybody still uses those terms. And still, in a lot of cases, there's somebody who has custodial care. The children are with them more than the other person. Sometimes the income of a new partner may be considered, but not specifically towards child support, and that's a whole different issue. In Illinois, typically, no. Income or resources of the child may be considered. So there may be a child who has say a trust from a grandparent. And if the child has a trust from the grandparent, the child has income, right? That is a consideration. Multiple families. If you're taking a look at the statute, you know that if you're going to have multiple families, if you're going to get divorced more than once and have kids more than once, and you're going to be expected to pay child support, or you're going to receive child support from somebody who is already paying child support to a prior relationship or prior group of kids, you know you're going to get less because they're going to get it first. That comes into play. Extraordinary expenses, any sort of extraordinary expenses or needs of the child, health insurance, custody, or the custody and visitation arrangements, is that whole time and responsibility. The more time you have with the kids, the more child support you can expect. Some enforcement mechanisms for collecting child support. Wage withholding, liens against property, tax refund, intercept, and credit reporting, and licenses. licenses, I'll just say that, that's usually through the Attorney General and the IVD, and it's not typically through private lawyers trying to track these people down. And you can threaten to take, say, their driver's license, but think about that for a second. The thing I always like to think about, or have you think about when that comes up, is if you're in Peoria, Illinois, and you take somebody's driver's license, that pretty well hamstrings their ability to have any meaningful employment, right? If you're in the city of Chicago, it's a hindrance to have a car, and a lot of people take public transportation that's readily available. Well, we don't have that. So there's some practicalities there too, but that's one of the things that is available. And then termination of support prior to majority. So typically, we think that a child is entitled to, or a child could be the subject of child support until they turn 18, unless they're emancipated before 18. And you'll remember emancipation when we talked about marriage and who can be married, and some people can get married before 18, and that whole conversation. One of the parents dies, there's no expectation of child support, from that parent. And then adoption and termination of parental rights. Let's talk a little bit about Illinois. Because you went and found the statute, that Illinois covers child support under 750 ILCS 5/505. And the Illinois model is called percentage of obligor net income. The model assumes that child rearing costs will be shared between the parents and assess a percentage of the non-residential parent's net income as the support to be paid to the parent or guardian who resides with the child or children. So who pays? In Illinois, both parents have a duty under the law to financially provide for the child or children. Both parents' financial income is utilized in calculating the child support obligation payment that the paying parent, non-custodial parent, must pay to the receiving parent, the custodial parent. In Illinois, either parent may be ordered to provide for health insurance and child support, but only one parent will have to pay child support to the other parent. And from looking at the statute and looking at the estimator, child support estimator, that we put both sets of incomes in to figure out, but typically one person's going to make a little more. Very rarely is it a wash. I'll tell you, in my own personal situation, it was pretty close to a wash, and we offset that by some distribution of property when we got divorced. So it wasn't significant enough that, rather than one person paying somebody else a small amount, it was pretty much a wash, and we worked that out through other things. But typically somebody's going to make less than the other. One person's going to make less than the other and be entitled to child support based on, again, looking at that time factor, who has the children more than the other, if at all. In Illinois, child support can be paid on a weekly, a bi-weekly, semi-monthly, or monthly basis by the parent who by the paying parent to the receiving parent. And child support's utilized for the child or children's expenses and looking at the best interest of the child, which you're familiar with from looking at the statute, to provide a stable home for the child or children. Some common things that we associate with child support are the child's residence expenses, utilities, child's educational expenses, the child's food, of course, the child's medical expenses. Child support should not be used by the payee parent for their own personal expenses, but essentially, so we go back to it does apply towards, shelter, food. Doesn't mean that the payee parent has to say, okay, well, I'm not going to eat out of this dish or this pan or whatever. You can cook one meal. So, in that sense, think of it as all the things a child would have enjoyed or expected that we would want a child to expect: food, clothing, shelter, medical care, education. Okay? Those things. Now, how is it calculated? In Illinois, how's child support calculated? It's calculated using the income shares model, and it'll calculate child support from one spouse to another spouse based on the combined net income of both parents. Essentially, we figure out each parent's net monthly income. We combine each parent's net monthly income. This number is both of the parents' combined net monthly income. We look at the schedule of basic child support obligations based on the parents' combined net monthly income and the number of children between the parents. We compute each parent's individual share of the percentage of the basic Illinois child support obligation. And then the payor parent will pay to the payee parent the percentage amount. The payee parent's share is automatically assumed to be spent on the child or children, so the payee parent keeps their share of the child support obligation. Some exceptions to the guidelines. There are exceptions. There are times when you can go outside the Illinois guidelines for child support. In Illinois, child support is awarded by applying the Illinois statutory child support guidelines, and Illinois courts will depart from these guidelines in certain situations if the court finds that application of the Illinois statutory child support guidelines would be unfair, unjust, and equitable, and not in the best interest of the child or children. Now, this is not a departure from the law prior to 2016, of the law as we know it today. It's always kind of part of it. And if you think about it, when we talked initially the very first week of the class, that this area of the law is law and equity. So the law part of it is the formula, the very strict sort of step-by-step, the formula. The equity is this part of the statute that provides the courts the opportunity to step in, and if the guidelines don't meet the best interest of the child or meet the circumstances of the situation, then the court can depart from the traditional guidelines. They have to look at the following factors to make this determination: the monetary needs and monetary resources of the child or children. So what are the monetary needs and the resources of the child? What are the monetary needs and monetary resources of the parents? They can look at the lifestyle the child or children would have enjoyed had the divorce not been executed. In other words, is it a great departure? Now, we're not talking about, they may have to move to a different house, or they may not have the same size yard or something like that, because obviously, as we've talked about almost all the way through the semester, after we got through marriage and started talking about splitting up the marriage, your circumstances are going to change. There's only one pot, and then when you split it into two pots with two sets of expenses, circumstances are going to change for everyone. And then finally, the mental, emotional, and physical condition of the child or children. So if there's any specific needs, special needs, additional needs, things that mentally, emotionally, or physically a child may have, it may require that the court depart from those guidelines to provide for those needs. So we have our child support order entered, and one of the questions and the final thing I'll cover is, how do you change that? Because a lot of times people, at least in my experience, and especially it seems to be earlier in the situation, once they have to pay or they're receiving and trying to make that whatever they receive meet the needs of the kids. And again, going back to what I just said about now you're living in two houses, you have two Ameren bills, and you have two, you're not on the same family plan on the phone and all that kind of good stuff. Like, your expenses just go up, and anybody that's lived through this knows that's true, right? Anybody in the class and anybody knows anybody who's lived through it, that's just the way it is. So the question always comes up is, well, they're making more money now. They got a raise, they got a blah, 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 and modification. Well, you can plan for those things depending on circumstances. So for instance, yeah, if your former spouse, or if the former spouse was in a profession or a job where they weren't paid a set income, then you would definitely want to have, say they were paid on commissions. You would want to have the child support, and it would likely be paid based on a percentage of whatever they earned over a given period by the month or whatever. And so that fluctuation would come. That's not what I'm talking about. So I'm talking about when people just want to challenge, or they want more, or they want to go back, and sometimes they want to go back whether there's a reason or not. This can be problematic because, one, just there's a practical matter. The courts don't want to have to referee these things without just cause, some reason. So what the statute says is, after the child support order is entered, once that order for child support, the final decision, is entered, it can only be challenged or modified if there's been a substantial change in circumstances that was unforeseen at the initial time of that judgment. So, a substantial change in circumstances that was unforeseen at the initial time of the initial child support judgment. So that, what that is depends on the facts. That could be the person paying child support took a new job making substantially more money. It could also mean that they didn't take a job, they lost a job based on something in the economy, their employer shut down or whatever, and they're no longer making that money. And the only jobs they're able to find are jobs that pay substantially less. So that's a substantial change in circumstances. It wasn't foreseen at the time of the initial order. And then child support will terminate upon the child turning 18 years old, or 19 if they're attending high school at the time they turned 18. And that's the general expectation. The question that comes up is, what about college expenses and all of that? And that's something that we won't talk about in this conversation. But that again comes back to a lot of times just an agreement by the parties, but it's sort of on the kid. And if the people have resources, they typically work all that out. If they don't have resources, it's on the kid. And to some degree, it's on the kid anyway. We can get into the weeds on child support in a lot of different ways, but the thing I want to leave this conversation with is, it is a formula. And once you go through the process of figuring out what we talked about last week, then you can sort of figure out that formula. You can start to figure out, how that works and who's paying what. And really, it's a lot of law, okay? It's a lot of law. Up to the point that it's not equitable. And if you have a circumstance where what the process and the step-by-step law says, then you won't get into equity, and there's not a lot to argue about. So from your perspective, as a person working for the lawyer who is going to be collecting this information and helping sort out what is to be paid or to be received, or for those of you who eventually go on, you become the lawyer yourself, whoever's going to help you do this. Most important things are you collect all the information you can, both from your client, and a lot of times your client has the information on their soon-to-be former spouse, so you can get that from them. But if you can't get that from your client about the income of their soon-to-be former spouse, well, then you get that through discovery. You get all of that information, and you do the calculations yourself. You make sure that you know what your client should receive or have to pay. You go over that with the lawyer, If there's any discrepancies, you work those out, but you're on the same page about what you think they should receive or they should pay. And it should be, little room for argument. My caution is not so much in regards to what happens at the courthouse. The caution is that if you don't master the numbers, if you don't master the calculations, and if you don't master the expectations, and your lawyer doesn't do that, then the client is going to be uneasy about whatever it is they're supposed to receive or pay. And I'll tell you what, your clients will go and double check your math. They can find the estimator themselves. They can go and do their own calculations. And as we've discussed many times, when you're changing or you're the person that's helping someone else change their life expectations, it becomes very personal to them. It becomes very emotional. So save yourself from being drawn into unnecessary drama. Save yourself from being part of some allegation of malpractice, whether it's warranted or not. Save yourself from having to deal with some sort of complaint to the ARDC because someone was dissatisfied with your service. And if you go back to Higgins' rule on communication about sending documents and all that and keeping your client informed as we're ethically supposed to do, this flows from that, right? What I'm saying here is really own these calculations if you're in a position to figure out what should be paid or should be received. Own it. Be prepared to explain it to your lawyer. And then my advice to you, because I know some of my colleagues out there who practice law, they may not exactly always want to have those conversations with the client, especially in family law. I would have you urge setting the lawyer up for those conversations with the client. And most of the lawyers that I know that do a lot of family law work and lawyers that specifically focus on family law work would have those conversations, but sometimes they may not. You as the legal assistant should make sure that you are prepared to prep them and answer any questions they have, them being the lawyer, on what the child support calculations are that you came up with. They need to approve or double check your calculations, and then you two need to figure out how you're going to communicate that to the client. And I would suggest that you set it up at least where the lawyer is part of that conversation, if not the lawyer having that conversation with the client. Just to cover your butt. To cover your butt. And you're covering your butt. You're honestly, my opinion is the lawyer's covering their butt because that's what they should do. That's just my opinion. This is child support. I appreciate your efforts these first 10 weeks. We really have 5 weeks to go and then the finals week. So as the weather warms up, don't shortchange this or any other class. All right? Kick up your effort a notch. Be sure to log in. And this is important stuff we're talking about in these next few weeks as much as anything we talked about in the first 9. So stay with me. I appreciate you. If you need me, you know where to find me.